అక్కడే ఉందండి. నేను హోస్ట్ తీసుకున్న తర్వాత అన్మ్యూట్ చేసి అక్కడ wait.
Good.
Yeah. మీరు అన్మ్యూట్ చేయండి ధర్మం.
Good evening, everybody. ఇంతకన్నా ముందుకు వెళ్ళదు. You're on live. Can go ahead. Mic is on. Live ఉంది.
No, let them assemble it.
Yeah, YouTube live ఉంది sir.
Good evening to you. Yesterday we were just discussing Order 41.
It's on invitation.
Order 41 discusses about appeals from original decrees. Yesterday I just gave you the contents of the memo of grounds that is filed before the appellate court. The grounds that are filed under section 96 read with order 41. First and foremost is any person aggrieved to the judgment and decree of the lower court has got a right of filing an appeal or what is called first appeal before the superior court. And that process is called an appeal or a regular first appeal. And normally the regular first appeal is filed under the provisions of section 96 read with order 41 rule 1. Order 41 rule 2 speaks about the contents of a memo of grounds. Here when we discussed plaint, I gave you the contents of plaint. In the same way as far as appeal is concerned, when you draft an appeal, first and foremost on the top, you say memorandum of grounds of regular first appeal filed under section 96 read with order 41 rule 1 CPC. Then you give the description of the appellate court. Suppose you are filing the appeal before the principal court, you say in the court of the principal district judge, Mechal Malkajgiri district at Malkajgiri, or whichever place the principal district court is located. Then all appeals on the appellate side are filed as AS. AS means appeal suit, and of whichever year it may be. Then between whoever is the aggrieved party is called the appellate, and whoever is the who is the successful party before the lower court is called the respondent. Then in the bracket you say appeal against the judgment and decree in OS number so and so, dated so and so, of whichever court it may be. Then you close the bracket. Then you, in the beneath it, you mention the cause title of the lower court and describe the parties as they are arrayed before the lower court. Then you start the appeal. Then the first thing which most of us write is the appellant begs to file this appeal on the following amongst other begs to file this appeal on the following grounds. Then the first one is name, address, and description of the appellant. Second one is name, address, and description of the respondent. And third is whoever is the advocate, the address for service, which we normally mention like a plain. You give the address with the cell number and the email number. And then you say the address for service of all summons on the respondent is the same as given above in the cause title. Then the next paragraph is being aggrieved by the judgment and decree in OS number so and so, dated so and so, on the file of so and so. The appellant begs to file this appeal on the following amongst other grounds. And he also mentioned that the description in this appeal is as per the parties arrayed in the lower court. Then you come to the grounds. And normally the practice is, because when you present an appeal, the appellate court is seized of the matter, it is also entitled to look at the facts. Whatever is your plaint, whatever is your written statement, a written statement the opposite side, brief facts you mention in the first paragraph. Then the second paragraph, you say the judgment and decree of the lower court is against the law, materials and evidence on record. Then next one is the lower court erred. Erred means committed a mistake in acting on surmises and conjectures. What do you exactly mean by that? Court had acted not on the merits of the case, but it had acted on presumptions and assumptions, which is erroneous. Third one is the lower court erred in misinterpreting the exhibits filed by the appellate, filed by the plaintiff or the defendant, whichever it may be. Then next one is the lower court erred in not noting down the errors, omissions, commissions, inconsistencies, contradictions in the evidence of the opposite side. Then next one is the lower court erred in misinterpreting the case law cited by the plaintiff before the lower court. Then after that, whatever contradictions are there, you try to extract the contradictions and highlight it in the memo of grounds. Then next paragraph is the appeal is valued for the purposes of court fee and jurisdiction at rupees dash, whatever is the valuation given in the lower court. It is it is the same valuation in the appellate court also, and the court fee is paid under the provisions of Section 49 Court Fees Act. Then the next paragraph is you mentioned that the appeal is within time and within the period of limitation, as the copies were obtained on so and so date, and the appeal is filed within 30 days if it is in the case of a district court, and 90 days if it is in the case of the High Court. Then after that, you mention that in the prayer clause, the appellant therefore prays for that the judgment and decree of the lower court in OS number so and so, dated so and so, of whichever court it may be set aside, and the appeal be allowed with cause throughout. Please bear one thing in mind, that the appeal need not be signed by the party, it can be signed by the counsel also, and with the where the appeal is filed, the place and the date you put, and of course as in plain you prepare the docket also. Please bear one thing in mind, that appeal is supposed to be a continuation of the suit. Whatever rules apply as far as a suit is concerned also applies as far as an appeal is concerned. Then suppose, let us say, in the lower court you have suffered a money decree, you can ask for stay. Stay means you can ask the court to keep the execution of the decree of the lower court in suspended animation till such time the appeal is heard. Then it doesn't mean that just because you file an appeal, stay should be granted automatically. The court will hear your stay application, then it issues a stay or passes a stay order, suspending or staying the execution of the decree of the lower court, and communicates it to the lower court also. But after that, it issues notice to the respondent calling upon him to be present in the appellate court on a particular day at a particular time, either by himself or through an advocate or through an agent duly authorized. Then the person to whom notice is issued appears by himself or engages an advocate who files a document into the court. It's called Wakalat Nama. That is the power to represent the party as far as the appeal is concerned. Then he has got a right of filing a counter to the stay petition. Then once he files a counter, what the appellate court does is it directs the person who has obtained stay, that is the appellant, to deposit 50% of the decretal amount or the cost of the lower court. Please remember, though you ask for stay, doesn't mean that you get a blanket order. No, it is subject to conditions. That is, the cost of the lower court has to be paid or deposited, or 50% of the decretal amount has to be deposited in court within a time frame. Then the question is like, unlike a suit, a petition can be filed for condonation of delay in filing the appeal. That is Rule 3A. Today's lecture is whenever there's a delay in filing the appeal, you can file an application to condone the delay in filing the appeal. Suppose the appeal has to be filed within 30 days. Suppose, let us say, there is a delay of 10 days. You can show sufficient cause why it was not filed within 30 days, and you can ask the court to condone the delay of 10 days in filing the appeal. Normally, the courts are not harsh as far as condonation of delay is concerned. On costs being imposed, the court condones the delay in filing the appeal. That is Rule 3A. Then sometimes Rule 4 is, it says, suppose let us say there are 4 plaintiffs or 4 defendants, and in that case there is a what is called there is a reversal of the whole decree where common ground is alleged. If common ground exists between the parties, one of the parties may obtain reversal of the whole decree where common ground. That means, suppose all the plaintiffs have got a common ground. Some of the plaintiffs may not have interest in filing the appeal. Why? Because it involves cost of the litigation. So one of the plaintiffs or one of the defendants who is aggrieved by the judgment and decree, irrespective of the fact that the other parties don't join, if there's a community of interest, that's a common ground is there to question the decree of the lower court, one of them can file under Rule 4. Am I making myself clear to you, please? That is, they say, suppose there are more than one plaintiff, some of the plaintiffs are not interested in filing the appeal. In filing the appeal, one of the plaintiffs or one of the defendants who has got a common ground can prefer an appeal under Rule 4. Then we go to, I've already discussed Rule 5, that is stay of execution. Just
Continue, sir. Interest. Sir, 22 is under 23 जमा ना. Rule 23.
so, as far as Rule 5 is concerned, as far as Rule 5 is concerned, stay can be obtained, a stay application can be filed under the provisions of Order 41, Rule 5. That means when you want the decree of the lower court to be kept in suspended animation, you can ask for stay. That means things stand where they are. Or the decree of the lower court cannot be executed unless and until the appeal is heard. That is Rule 5. Yesterday I discussed that also. But Rule 6 goes further by saying that in case you file an appeal and you ask for stay, the appellate court does not give you a blanket stay. The appellate court directs you to furnish security as far as the cost of the lower court is concerned, and 50% of the decretal amount will be directed to be deposited before the court within a particular time. That is what Rule 6 says. Then exercise of powers in appeal. Whenever an EA is dismissed by the lower court, the appellate court can hear the matter and even an appeal lies under Rule 8. Then what is Rule 9? See, when you file a plaint before the lower court, the plaint is checked and found correct. Then the presiding officer, who is the allotting judge, endorses on the docket, register the suit. In the same way, when you file an appeal before the appellate court and all the formalities have been complied with, and you file a copy of the judgment, copy of the decree, and also the appeal grounds in duplicate. And nowadays, of course, nowhere it is written that verification affidavit has to be filed in appeal, but some of the courts are insisting on verification affidavit. But anyhow, let us not have a discussion on that. If they want a verification affidavit, better you file it. Then after that, you pay the BATA, or what is called the process fee, to issue notice to the respondent or respondents, as the case may be. And the form which you enclose along with the process or along with the BATA is what is called notice of the date fixed in appeal. There are printed forms available. Notice to the respondent for the day fixed in appeal. Then notices go to the other side. And please remember, as far as the BATA is concerned, whatever petitions you file or memo of grounds you file, as many parties are there, you must furnish as many copies and file it to the court. And if you are asking for stay, then the stay petition and the affidavit which you file, also copies to be forwarded to the other side, and you pay the BATA. And please remember, whenever you file an appeal, filing the copy of the decree is mandatory. But suppose, let us say, now, of course, when I come to amendment, I tell you, when the decree is not prepared by the lower court on the day when the judgment is delivered, you can file an application before the court. Sir, please permit me to file the appeal without the copy of the decree. As and when obtained from the court, I shall file it at a later date. Then the filing of the decree copy can be dispensed with in special circumstances. Then once the appeal is filed, the appeal is checked by the section, by the AO or the superintendent, and if it is found in order, the superintendent makes a note as to the contents of the appeal. Then it is placed before the allotting presiding officer on the appellate side. Then he goes through the appeal grounds, and if all the formalities have been satisfied, then he endorses on the docket, register the appeal. But please remember, it is the duty of the section to verify the caveat register also before the appeal is registered. Why? Because there are some people who file a caveat that no order or no stay should be granted in appeal without notice to them, to them or to their advocate. Then in that particular case, the caveat number, the date on which the caveat is filed, and the person who has filed the caveat, and regarding which property or which judgment that particular caveat is filed, has to be noted by the superintendent or the AO who checks the appeal. And please remember, once the caveat is filed, the appellate court normally is reluctant to pass a stay order. They issue notice to the opposite side. Then once the notice is, of course, there is no bar as far as numbering the appeal is concerned. But as far as your stay petition is concerned, notice will be issued on the stay petition. And the other side will be given an opportunity of filing the counter and opposing the stay petition. And normally the other side opposes for simple reason. He will be interested to recover the cost that has been granted by the lower court, and also 50% of the decretal amount he can ask the court to direct the appellant to deposit 50% of the of the amount covered by the decree. Then after that is complied with, court normally issues a stay order. No court refuses to stay the execution of the decree of the lower court, especially in appeal, because an appeal is supposed to be a continuation of the suit. A suit does not, a litigation does not end with the lower court. It continues to remain on record till the appeal also. And that's why I said that appeal is supposed to be a continuation of the suit. And once the appellate court is seized of the matter, then the lower court, hands of the lower court is tied. And please remember, just because you filed an appeal, it does not mean that the other side or the person who has obtained a decree cannot execute the decree. So long as no stay is granted by the appellate court, it is open to the successful party to file an execution petition under the provisions of Order 21. As an appellant, you as a defeated party, you cannot tell the lower court, "Sir, I've already filed an appeal. Where is the question of executing the order?" Please, the lower court will tell you, "Sir, have you obtained stay?" No, sir. If you have not obtained stay, then suffer. And you cannot wait till your appeal is disposed of. There is no bar as far as execution is concerned. So that is the reason why we resort to filing an interlocutory application along with the appeal under Rule 5. We file a petition for stay of execution under Order 41, Rule 5. And please remember, it's not a blanket stay. Even if the court grants you stay, it is not a blanket order. What the court will say is, please deposit the cost of the lower court within 4 weeks or 8 weeks, as the case may be. And once you pay once you deposit the cost, it is entered in an accounts register. You can file a memo into the court, "Sir, on so and so date, complying with the orders of this court, I have already deposited the cost." And once cost is deposited, stay is automatically granted unless and until the other side files a caveat and he has to be heard as far as the stay is concerned. So as far as security is concerned, it means 50% of the amount has to be deposited or security has to be furnished as far as the suit amount is concerned. So that is Rule 6. Then, as far as Rule 7 is concerned, it is said exercise of powers in appeal. What do you mean by exercise of powers in appeal? Whenever an application is filed before the lower court and an appeal is filed, then in that case, the appellate court, for all practical purposes, gets converted into the position of a lower court. What you could have argued before the lower court, you can argue before the appellate court. And the appellate court has got ample powers to hear the matter afresh and dispose of the matter according to law. Then the next rule is, once your appeal is filed, it is checked by the office and then found in order. Then the court orders the presiding officer, who is the allotting judge, endorses on the docket, register the appeal. Then once he endorses on the docket, register the appeal, it is a duty of the Sharasadar or the CMO or the superintendent or the AO to enter the contents of the appeal in a register called appeal suit register. The contents of the appeal, who has filed the appeal, what is the number of the appeal, to which court it has been allotted, what is the date fixed for appearance, so on and so forth, will be entered in a register called appeal suit register. And please bear one thing in mind, like what you file a plaint, normally suppose you file an appeal on the last day of limitation, it is better, it may not be numbered immediately, but note the SR number. SR number means suit register number. The advantage of noting the suit register number is it's prima facie proof of having filed the appeal on a particular day at a particular time. And all your papers, including your wakalatnama, the court fee which you have paid in the appeal, then the court fee which you have paid in the process, the court fee which you have paid on the judgment, court fee which you have paid on the decree, so on and so forth, will be entered in the SR register. And once it is entered in the SR register, it's prima facie proof of the appeal having been filed on a particular date. And the advantage of noting down the SR number by you as an advocate is, whenever you want to pursue the appeal, you can give the SR number to the superintendent and then trace out your file and see what are the remarks made by the presiding officer. Then, one more thing you must remember is, when you file a stay petition, a blanket stay is not granted You are given time or you are asked to furnish security for the decree granted by the lower court and also deposit the court cost that has been awarded within a time frame. Then once the appeal is registered, then under next is a time also will be given to you to furnish security, that is to deposit 50% of the decretal amount and the cost of the court, the cost of the lower court. Then the appellate court has also got powers, that is without service of notice to the lower court that an appeal has been filed, it can dismiss the appeal even at the threshold. That is what rule 211A speaks about. Then what happens is, once the appeal is numbered, notice is issued to the opposite side directing the opposite side to appear before the court on a particular day at a particular time, either personally or to a pleader or to an agent duly authorized. And on that particular day at that particular time, the party has to appear either personally or through his agent or through his advocate. And the advocate who appears in the court files a document in the court called Wakalat Nama. Then, when you file the appeal, under the civil rules of practice, it is clearly laid down that you must furnish extra copies of the judgment and decree, which you have filed in the form of a certified copy to the respondents. As many respondents are there, that number of copies you have to furnish. But normally, we advocates don't do it. But please remember, civil rules of practice says copies of the copies of the judgment and decree has to be furnished to the opposite side, and copies of the appeal grounds and copies of the petitions which you have filed before the court also has to be furnished to as many respondents as they are, as far as the appeal is concerned. It is absolutely mandatory. Then once the appellant or once the respondent appears before the court, his advocate files the Wakalat Nama and takes time for filing the counter. Then, if let us for a moment say stay has been granted for a limited duration of time, like what is called interim injunction, you must file a memo or petition before the court. Sir, please extend the orders of stay. Then, once the other side files a counter, the interlocutory application is heard and disposed of, and you will be directed to pay the cost either personally to the counsel for the opposite side or deposit the cost into court and furnish security to the extent of 50% if it is a money decree. Then after that, the court fixes a day for hearing the appeal. Then what the court does is, it calls for the records from the lower court, and normally records don't come immediately. It takes its own time, and when the records arrive in the court fixes a date for hearing the appeal on both sides. Please remember, as far as appeal is concerned, no evidence is recorded by the appellate court. All evidences end with the lower court. Then here, then what happens is the court gives you, there are what are called hit cases. There is identified cases which are old cases which have to be heard and disposed of according to the directions of the High Court, and they will be given priority as per the pendency of appeals or matters before the appellate court. And then the question arises, sir, who should begin the arguments? In the lower court also, there's a tug of war going on between the plaintiff and the defendant. Sir, the defendant has to start the evidence. Then plaintiff says no. Then the plaintiff says no, sir. Defendant has to start. The defendant says plaintiff has to start. There are some issues where the burden is on the plaintiff. There are some issues where the burden is on the defendant. Then in that case, suppose it is a money suit. The defendant pleads discharge. He says, sir, no amount is due and payable. I have already paid the money. Then once he pleads discharge, it is the burden of proof is on the defendant to prove how he has paid and what circumstances he has paid and what date he has paid and what is the proof of payment. He has to get into the witness box first and then begin his evidence. But in the appeal, the question arises, sir, who should begin? Normally, in all probability or in all cases, it is the appellant who has to start the arguments. There is no question of respondent starting arguments in appeal, please. Please bear that in mind. And once the appellant finishes his arguments, it is the duty of the respondent or the respondents, when they are represented by different advocates, to argue the matter in appeal. Then, sir, how should we argue in appeal? Please remember, everyone has got his own style of arguing a particular matter. For example, myself and other people who have got sufficient standing in the profession, we are from the old school of thought. We start from the pleadings. We start from what is called, what is mentioned in the pleading, the highlights of the plain, highlights of the different highlights of the written statement, and also the evidence, the issues that are framed, and then the witnesses who are examined, and then what PW1 says, what PW2 says, what PW3 says, what DW1 says, what DW2 states, what DW3 states, and then the inconsistencies, the admissions, and the contradictions in the respective evidences of both the parties is highlighted by us. There's an old system of arguing a matter. But please remember, neither we have the patience nor the judge has the patience to go on a traditional style, because now we are in the era of advanced technology. Judges have also become technocrats. They have become what is called people who don't have pay. With due respects to the judiciary, they don't have patience to hear the appeal. Then there are some judges who hear an appeal as if they are hearing a summary suit. Please remember, appeal is a very, very difficult litigation to be argued, because normally you have lost in the lower court. You don't want to lose it again in the appeal. And please remember, as far as the first appellate court is concerned, it is the final fact-finding authority as far as the hierarchy of courts are concerned. So whatever contradictions are there, whatever inconsistencies are there, whatever misappreciation of evidence is there, whatever errors have been committed by the lower court, and whatever case law has been cited, how far it is applicable to your case, how the lower court has misinterpreted the particular case law, or does not look into a material question or material admission made by the opposite side, ignored it, all these fallacies will have to bring it to the notice of the appellate court. That's why I said in a lighter way that the appellate court acts like what is called a mother-in-law. As far as the lower court is concerned, it is supposed to be the daughter-in-law. Whenever the daughter-in-law commits a mistake, the mother-in-law pulls her up, says, Amma itla cheyoku. But here the mother-in-law, sometimes they become overbearing also. It leads to a friction between the mother-in-law and daughter-in-law. But here the question is, I'm not for a moment commenting upon that, but in appellate court has got enormous powers. It has to have enormous patience, and it must listen to a party, listen to an advocate who is arguing the matter. Please remember, we are paid for arguing a matter before the appellate court. When I started my practice in the initial stages, we were sure that if we lose a case in the lower court, we are sure to win it in the appeal. But now, unfortunately, everything has become mechanical, where the lower court judgment cut and paste, as you use in the computer language, that is being adopted by the appellate court. And last, they say strenuous arguments have been advanced by the appellant and the respondent, but I find no reason to dissent or disagree with the findings of the lower court, and therefore the judgment of the lower court is hereby confirmed. It is something like operation successful, but patient died. That's what the appellate courts have been reduced to. So one thing is this, whether they allow your appeal or don't allow your appeal, do your duty, do it according to your conscience. Then we go to what is called service of notice and the right to begin, and then dismissal of appeal for default. Under Rule 17, it is said, whenever the appellant is absent, or when the appellant does not argue a matter, then under Rule 17, the appeal is dismissed for default, for non-prosecution, as you may call it. Then we go to the rehearing of the appeal. Then Rule 19 says why you were prevented from arguing the matter on that particular day, or why you were not present on that particular day, why there was no representation of that particular day, how the default order is working havoc. As far as you are concerned, when sufficient reasons are shown under Order 41, Rule 19, if you are the appellant, you can ask for rehearing of the appeal. Then, as far as the next rule is concerned, the appellate court has also got the power to adjourn the hearing from time to time on sufficient reasons being shown. Then the next rule is, suppose, let us say, you as the respondent is not present or your counsel is not present on the day when the appeal is posted. Then in that case, the respondent will be set ex parte and then the appeal will be proceeded against. But here the rule also provides that even a respondent who has been set ex parte and has been deprived of hearing, he can also file an application for rehearing as far as his defense is concerned. Then we go to a very important provision called cross objections. Cross objections means, what do you mean by cross objections? Instead of filing a regular appeal, suppose some issues are held against the defendant who is aggrieved by those findings, instead of filing a regular appeal, in the same appeal filed by the opposite side, you can file what is called cross objections and state as to how the issues have been held wrongly as far as you are concerned. And cross objections also, you have to pay the necessary court fee as directed by the court instead of filing a regular appeal. Then 23A speaks about what is called remand. Suppose the appellate court finds that the lower court has not appreciated the issues properly, or the evidences have not been evaluated properly, or there's a miscarriage of justice, then the matter is sent back to the lower court, remanded to the lower court to try it afresh and then dispose of the matter according to law. Suppose the court in next rule is, there they say, suppose the evidence is sufficient, it is sufficient to dispose of the appeal, the court hears the matter and disposes it off immediately. Then sometimes it may so arise that additional issues which might or ought to have been framed by the lower court have not been framed. In that particular case, the appellate court can act upon it and frame additional issues and remand the matter back to the lower court. I have come across one appeal which my office is arguing before the Karimnagar court, where the appellate court, where the lower court has observed that additional issues arise as far as the determination of the suit is concerned. But the lower court abdicated its duty by saying the parties know their respective cases, parties have got the necessary documents, parties know how to interpret the facts, parties know how to interpret the documents. I do not find any reasons to frame issues. That's a material irregularity committed by the lower court. That is covered by AR 2001 Supreme Court case, where they say when additional issues arise and the lower court does not frame issues, it cannot abdicate its duty of framing the additional issues as a material irregularity which can be gone into by the appellate court, and in all probability, either the appellate court can frame additional issues or send back the matter to the lower court by way of remand, frame those issues and give its findings after giving adequate opportunity to both the sides. Then order 41 rule 27 also I discussed yesterday, where let us say some documents have not been gone into by the lower court, or let us say you have not been given an opportunity of bringing the subsequent facts to the notice of the court by filing the documents, then in the appellate court you can always show the reasons and then file an application under order 41 rule 27 to receive additional evidence. And once you file that application, you have to give the copies of the documents which you are filing fresh to the opposite side. Opposite side will be given an opportunity of filing its counter. Then the matter will be heard immediately, or the appellate court says, I will dispose it off along with the appeal. If the court wants to dispose it off along with the appeal, what the appellate court does is, it frames the additional issues, takes the additional documents, and says, as far as marking is concerned, I'm remanding it back to the lower court. Then we pass on to what is called contents of a judgment. When the appeal is heard, what is the step the appellate court takes once the appeal is filed? It calls for the records, and then After that, issues notice to the other side. Then the other side appears. Then once the records come to the court, the appeal is heard on both sides and disposed of accordingly. But as far as the judgment of the appellate court is concerned, it is the appellate court is under a duty to say the brief facts state the brief facts of the suit, brief facts raised in the defense, and then discuss the findings of the lower court issue by issue, and then the arguments that are advanced by the respective party to sustain the appeal or for dismissal of the appeal also will be noted. And if the court dissents with the judgment or the findings of the lower court as far as some issue is concerned, the appellate court is bound to give reasons. So as far as the judgment is concerned, the designation of the appellate court is mentioned, then the appeal number, then who is the person who has filed the appeal, appellant, and the person against whom the appeal has been filed, you call the respondent. Then the next year it will be judgment. There they'll say this appeal coming up before me on this the day of so and so, in the presence of so and so advocate for the appellant and so and so advocate for the respondent, this court passes the judgment in the manner hereinafter mentioned. Then the court extracts the pleadings, extracts the evidence, and also goes issue by issue, and the findings of the lower court as far as the issues are concerned, the case law that has been cited by the parties, the inconsistencies, the admissions, and the contradictions as far as the findings are concerned will be noted by the court, and the appellate court, if it finds that the judgment and decree of the lower court is perverse and against the law or against the facts and circumstances, then it allows the appeal and sets aside the judgment and decree of the lower court. Then, if it is satisfied with the judgment and decree of the lower court, it confirms the judgment and decree of the lower court. But if the judgment of the lower court requires variation, it varies the various terms and conditions or modifies the judgment and decree of the lower court. Then beneath it, it says the appeal is hereby allowed and the judgment and decree of the lower court in so and so is set aside with cause. Then down it will be said, given under my hand and seal on this day of so and so. Then the presiding officer signs on it, and then it is also the judge's seal also will be put on that, and every party in an appeal, be it the appellant or the respondent, will be entitled for a copy of the judgment and decree if applied according to law. Then after 7 days, the parties are given the opportunity, within 7 days, to file the memo of cost. Whatever cost is incurred in the appeal, both the appellant and the respondent will be given an opportunity of filing the MC and FC as they call it. And once it is filed, a decree is prepared by the appellate court according to law and delivered to the party. And once the judgment, suppose the judgment and decree of the lower court is set aside in appeal, then in that case, the decree of the lower court merges with the appellate court decree. That is, what is executable is the decree of the appellate court and not the decree of the lower court. But as far as execution is concerned, appellate court has no power of execution. Necessarily and compulsorily, you will have to go back to the lower court and file an execution proceeding. Then afterwards, suppose this is what all it is what is called. Then what happens is you are entitled for copies, and one copy is sent to the lower court for the record. This is what all Order 41, Section 96 speaks about, please. Then we go to Order 42. You can kindly delete, please. It's only 2 rules are there. Then you can go to Order 43, Section 104. Order 43, Section 104 deals with what is called appeals against orders. That is, they are normally numbered as CMS, or what is called civil miscellaneous appeals. And in order to file an appeal against an order in an interlocutory form before the appellate court, you must see whether your order that has been passed under which provision and whether it's an appealable order. Order 43 postulates the various circumstances under which an appeal can be filed. That means the first one is Order 7, Rule 10. Suppose, let us, I think most of now it's a fashion in every court. Once a suit is filed, the defendant appears. Immediately the next day, a rejection petition is filed under Order 7, Rule 10. Please remember that's absolutely ridiculous. If a rejection petition is filed just to throw out the plaint at the threshold, it works hardship to the party who has come to the court, spent money, paid the court fee, expecting that some justice will be done to him. And next day, if it is going to be thrown out, the reputation of the advocate also receives a bang. So that is the reason why our High Court, the division bench of our High Court, in the judgment reported in 2021 5 ALT 177, the judgment rendered by Justice Shamim Akhtar and Apparao has clearly laid down that a suit cannot be thrown out at the threshold. And what the suppose such an application is filed, it is open to the court to frame an issue and hear it according to law and then dispose it off in the end. And a rejection petition can be filed only as an exception, but not in the ordinary course. So that landmark judgment now is very, very useful to the plaintiff to question the rejection petition. So any order that is passed under Order 7, Rule 10 is appealable, and a CMA can be filed by a person who is defeated. Then Order 9, Rule 7. Can you tell me, sir, what Order 9, Rule 7 says? Suppose you as a defendant, you are set ex parte and you have filed an application to set aside the ex parte order, but the court dismisses your application. Or let us, I put it the other way around also. Suppose application for setting aside ex parte order has been allowed. Then either a party to the litigation, be it the plaintiff or the defendant, can file an CMA or can file an appeal, a miscellaneous appeal under Order 9, against an order in Order 9, Rule 7. Then Order 9, Rule 13. Suppose an ex parte decree is passed and the defendant asks for the decree to be set aside on sufficient grounds and files it within time, but the court, while deciding that application, dismisses the application or allows the application. Then either party can file a miscellaneous appeal before the appellate court under Order 43, read with Section 104. Then we go to what is called Order 21, Rule 21. Many questions were asked on this when I was dealing with execution, simultaneous execution. So who files that, sir? It is filed by the decree holder. He wants to proceed against the JDR for attachment of salary and attachment of movable property or immovable property. And the court allows that application, or let us say it is dismissed. Then in that case, a civil and miscellaneous appeal lies to the district court or the high court as the case may be. Then we go to, suppose a draft of a document is filed and it has been, objection has been raised to it and it has not been properly discussed under Order 21, Rule 34, a CMA lies to the district court or the high court as the case may be. Then we go to Order 22, Rule 9. What is Order 22, Rule 9? They are all called incidental proceedings. I said a civil litigation does not end with the death of a party. If the plaintiff dies, his LRs can be brought on record. And if the defendant dies, his LRs can be brought on record. And the provisions are Order 22, Rule 3 and Order 22, Rule 4 respectively. And what is the period that is granted to you to bring the LRs on record? It is 90 days from the date of death. But suppose the 90 days gets exhausted, the suit dies a natural death as far as the dead person is concerned. Then we have to revert to what is called Order 22, Rule 9, which says that the whatever abatement has occurred when the LR application is not filed within 90 days, under the provisions of Order 22, Rule 9, you have got a further period of 60 days to set aside the abatement. So now we are at 90 days plus 60 days, that is 150 days. Suppose, let us say, even that 60 days period expires, then you have got our Zinda Tirismat as far as Limitation Act is concerned, Section 5 of the Limitation Act, explain each days of delay and ask for the delay to be condoned. Then how the court hears the matter? court hears the first delay continuation petition, then hears the abatement petition, then hears the LR petition. That's the stages in which it is heard. Suppose one of the application, like what is called setting aside abatement, is dismissed by the lower court, then you have got a right of filing an appeal or what is called CMA before the superior court. Here, suppose in some matters leave is not granted to defend or to file an application, then in that particular case, you can always file an appeal before the appellate court. And let us now go to order 25, rule 2, where dismissal of an order to set aside dismissal orders. Here, suppose you file an application to set aside a dismissal order, but the court does not do it, you can always file a CMA before the appellate court. Then the next contingency is orders under order 35. Yesterday I discussed about it. What is order 35, sir? Interpleader suits. Interpleader suit, suppose the court does not grant leave to file the suit or dismisses your application to take leave, then in that particular case, an appeal can be filed before the appellate court. Then, under order 38, any order that is passed, either allowing an application for attachment before judgment or dismissing an application for attachment before judgment, then in that case, a CMA can be filed before the district court or the high court, as the case may be. Then under order 43, rule 1R, suppose you file an application for injunction, injunction is not granted or injunction is granted. Against that, agreed by that order, you can file a miscellaneous appeal under order 43, rule 1 bracket R. Here, when you file an application under order 41, rule 90, when an appeal is dismissed for default and the court does not hear the matter, there also a CMA can be filed before the Honorable High Court, because the question is, as far as the appellate court is concerned, when it has not heard the matter properly and the refusal is improper, then you can file a CMA before the superior court. Then once a remand order is passed by the appellate court or whatever it is, then under rule 23, you can always file a CMA before the high court. This is as far as appeals against orders are concerned. The last small provision I shall discuss and then stop. Then we pass on to order 47, review, granting of review order under order 47, read with section 114, Civil Procedure Code. Here, I'm sorry, before going to that, we'll go to order 44, appeals by indigent persons. What is the provision relating to suits filed by indigent persons? We discussed it yesterday and every day we have been discussing it. Suit filed in forma pauperis and a leave petition filed to sue as a pauper. When the person concerned who locks at the doors of the civil court has no means at all or has no sufficient means to meet the obligation towards payment of court fee, and the pauperism is disallowed by the lower court, or the pauperism is allowed, to put it the other way around also, a CMA lies before the appellate court as against granting leave or not granting leave, then that an appeal can be filed under the provisions of order 44. Then we go to what is called order 47. Order 47 has to be read in conjunction with section 114 of the Civil Procedure Code. That means review. Please remember, we pronounce it as review, but review is not the correct pronunciation. Review. Review means view the matter again. Have a fresh look at the matter. Whenever there's a latent or patent error, misappreciation of evidence and facts, or misappreciation of the case law, and a judgment has been passed, then before the same court, you can ask the court to review the matter and decide it afresh. Then in that particular case, whenever a review petition is dismissed by the court, you can go to the superior court and try to agitate the matter. Then we go to the next provision called appeals by indigent persons. I discussed this also yesterday, or 3 times I've discussed it. That is, here it is said, who is an indigent person? Indigent person is a person who has no means, or a person who has means but no sufficient means to meet the obligation towards payment of court fee. Then in that particular case, he requests the court to permit him to sue as a pauper. And then after an inquiry is held, the court permits him to file it as a pauper. And suppose a pauper application is filed and it is dismissed, then in that case you can file a CMA before the appellate court. And then once a CMA is filed, notice is issued, the other procedure goes on. Suppose, let us say, the pauperism is allowed, the other party is agreed, the other party can definitely file a CMA under the provisions of Order 47. I think with this we shall stop, and now the period starts for the interaction piece. You can just clear your doubts clear. Just a minute. Yes, Mrs. Gauzia.
Sir, good evening, sir.
Good evening.
Sir, what is the difference between floating charge and fixed charge, sir?
See, floating charges, suppose let us say primary securities are taken at the time when the loan is granted, then that is called a floating charge. That is, even if subsequent loans are advanced, it floats like a leaf in water. It continues till such time the loan is completely satisfied. That is what is called, even if fresh stock comes, the charge continues. No need of execution of fresh documents. Fixed charge means, suppose there's a default in payment of the amounts, then the floating charge gets converted into a fixed charge, and the financial institution or the bank can proceed against that charged property irrespective of the fact that new material is coming. That is called a fixed charge. Floating charge means till such time the payment is made, it floats like a leaf in water. Fixed charge means once it is a NPA, or what is called non-performing assets, it is transferred to protested bills and to the NPA and what is called recall debts. In that particular case, the floating charge gets fixed on that particular security over which the financial institution can proceed. Am I making myself clear to you, Mrs. Gauzia Ahmed?
Yes, sir. Thank you, sir.
Next.
Sir, namaste.
Namaste.
Sir, review petition dismiss చేశారు సార్ ఇవాళ. దాని మీద అపీల్ ఉంటుందా?
Against review petition, which court dismisses it?
Family court, sir. Rangareddy family court.
Rangareddy family court means you have to go by way of filing a
review petition.
Review petition is
against the orders of the sheet court orders. The respondent wife filed the review petition.
Right.
Today, review petition is filed.
Yes, dismissed.
దాని మీద అపీల్ ఉంటుందా సార్?
Appeal లేదు, revision lies to the high court before the bench.
అంటే డైరెక్ట్ గా ఓన్లీ ట్రయల్ కోర్ట్ ఆర్డర్, ఎర్లీగా వచ్చినటువంటి ట్రయల్ కోర్ట్ ఆర్డర్ మీద హైకోర్టు అపీల్ వెళ్ళాలి, ఫ్యామిలీ కోర్ట్ అపీల్ వెళ్ళాలి, అంతే కదా సార్?
Family court appeal does not lie, sir. It's only revision which lies against an interlocutory order.
అచ్చా, రివిజన్ పిటిషన్ మీద
Review మీద only revision lies to the high court.
అచ్చా, ఓన్లీ రివిజన్ పిటిషన్ హైకోర్టులో ఓకే సార్.
It comes up before a bench. All family court matters.
ఓకే సార్, ఓకే సార్. థ్యాంక్ యూ సార్. నమస్తే.
Good evening, sir.
Good evening.
Good evening, sir.
Good evening, madam.
Sir, in an evidence part, one brother, he was died. Before that, he gave a written paper.
Yes.
Signing on white paper. He gave that he is relinquishing his rights of property to her sister, his sister.
Right.
Against her taking 30 lakhs of amount of joint property.
Right.
So that will be useful for the evidence, sir.
Madam, the person is dead and gone. The question arises, whether the payment has been made or whether it is taken under circumstances which gives rise to suspicion. Number 3 is to say whether it can be used for a collateral purpose to prove the nature of the transaction by saying already amount has been received and signed by the party. The question is relinquishment has to be admitted. But one thing is, if it requires stamp duty, then you'll have to get it validated.
That paper has to be validated. Achha, sir. Okay. So that can be.
It can be looked only for a collateral purpose, not for the main purpose, please.
Okay.
Right.
So that property cannot be signed, cannot be sold without the.
Exactly. You're right.
Okay. I got it. Thank you, sir.
Welcome.
Hello.
Yes.
Sir, good evening, sir.
Good evening, sir.
Sir, difference between review and appeal.
Yes.
అది ఎలిబరేట్ లో చెప్పండి సార్.
అపీల్ అంటే సార్ ఇప్పుడు కింది కోర్టు జడ్జ్మెంట్ అవుతుంది కదండి, డిగ్రీ అని, దాని మీద మీరు డిస్ట్రిక్ట్ కోర్టు కానీ హైకోర్టు కానీ వెళ్తారు. సపోజ్ ఇన్ ది అపీల్ suppose the court holds it against you. Let us take it for hypothetical case. And then suppose it is misappreciated as far the vis-a-vis the facts are concerned. You can ask the court, sir, there is an error apparent on the face of the record, or the facts have not been properly appreciated, the case law has not been properly interpreted. Please have a relook at the matter or review the matter or consider it afresh. That is what is called review. But appeal is the judgment and decree of the lower court can be looked into from all angles and then disposed of accordingly. But review is when the appeal is filed and the appeal is dismissed, let us say, then the facts have been wrongly appreciated. Then in that case, under Order 47, read with Section 114, the same court which decided the matter, you can ask the court to have a relook at the matter. So that is a difference, please.
Sir, and second one is, sir, please citation చెప్తున్నారు సార్, సూట్ కెనాట్ బి థ్రోన్ అట్ థ్రెషోల్డ్ అని చెప్పి చెప్పారు.
2021 5 ALT 177.
So the names of the parties ఏమన్నా చెప్తారా?
That is a leading case. That is a judgment of Justice Shamim Akhtar and Apparao, please.
Okay, sir. Thank you.
You can get it, no problem.
Thank you, sir.
Right.
Sir, I have one other question, sir.
Yes.
Under what circumstances a court can reject a document produced before the court? Is it mandate to make an endorsement of the rejection? State the case where an admitted, sir, 1 minute, sir.
No, please.
State cases where an admitted document may be returned.
A document which is filed into the court, which is not according to law, which is not properly stamped, which is not properly registered, or which under any law for the time being in force is inadmissible in evidence, or a Xerox copy that has been filed, or which has not been properly authenticated, and suppose a document is filed under 65B and it is not properly certified as an authenticated copy, in all those circumstances, the court, for reasons recorded, can dismiss or can reject a document. Am I making myself clear to you, madam?
Yes, sir. Is it necessary to make an endorsement regarding that rejection, sir?
The court has to make an endorsement, and once it rejects it, it's subject to revision to the High Court.
Yes, sir. Thank you.
Anybody else? Any questions on chat box?
No, I don't think so. Shall we conclude the class today? All right. Thank you. Thank you, Ananda.